We got family law attorney Lana Shearer with us. One quick question before we play our silly little game here, Lana. This is from Alyssa.
Hi, Alyssa.
You mentioned earlier that if you lose your job because of COVID-19, that you can go into court and ask for a modification of payments, spousal payments, child support payments.
In Sacramento County,
Okay.
so they just issued this new on Saturday that you can file a request for orders for a modification of support, and they are taking those and processing those right now.
So check your local county court if you're not in Sacramento County. Does it work the other way? Alyssa says, if my husband's ex-wife loses her job due to COVID, can she take him back to court for more child support?
Yes, it goes both ways. It's for anybody who's suffering because of the loss of job.
And we got this email from Allie.
Hey, Allie.
She says, please, please, please love your children more than you hate what the other person is doing.
Amen.
Do not put them in the middle of your fight with your ex. If your kids are old enough, they will remember, and it will bite you in the keister. Thank you guys for being the sane voice in this chaos. I'm going to step off my Oprah pedestal. That's a nice note.
That's a really important message, though, seriously.
Back to, I do wonder sometimes, we all wonder this. Dawn, of course, is the nice one on the show. And she'll say things like that. And when you're not around, I'll go like, do you really think people that think like that are going to respond and listen to us? I mean, are you hoping that we can just reach a few people?
I hope so, exactly. I hope you can reach a few. I mean, change their mind, influence them a little bit. It goes a long way, especially for the children.
Not all, but I mean, people do change over time. They realize they're being jerks, and asses, and they have self-reflection. So, I mean, it could happen.
Right now, we have nothing but time for self-reflection.
Exactly.
Back to questions, rad@radradio.com. You can call us 888-989-9811. This one says, this extra time now that kids aren't in school, how does custody time work in regards to this time? Split? Is one parent only responsible?
No, it continues. So the court has issued directives. Parenting time continues as if the children were in school, if it's a regularly scheduled school time. So spring break, you'd handle it like spring break. If it was school time, even though school is closed, you handle it like your regular parenting time.
Hello, Diane. Good morning.
Good morning.
Go ahead.
My question regards visitation rights. My brother recently passed away, and his ex-wife has cut all ties with our side of the family from our niece, and she's going to be 10 this year. I was just trying to see if there's anything that we can do in order to maintain relationship with her.
Oh, that's too bad.
Oh, I'm so sorry about that. There is a court process that you can go to, but how recent was it that he passed away?
January.
Oof.
December of last year, January, we had his service.
I'm really sorry about that. There is a process through the courts for visitation, especially grandparents' visitation. But, I encourage you just to continue to try and reach out and work out something informal because one parent can possibly stop the other family from seeing the children, as hard as that may be. But there is a court process where you can request the grandparents' visitation. I mean, the court wants to see that people who are important to the children and have a bond with the children are able to continue relations. But
would any of that be looked at right now under the current environment?
Not likely, no.
Is it worth filing just to get it on record right now?
Everything's, in my opinion, honestly, file it to get it on record. We're going to have a ridiculous backlog when we get back into session. So I encourage, if it's important enough to you to file it, get it on record, get a calendar date, and then, try and work it out, and you'll have to go to mediation. So get it filed. In terms
of the backlog, when it comes to family court, if they're making these decisions on, say, ex parte things, it's as an emergency basis, will it be first come, first serve in scheduling everybody that's in line, or will that also be based on merit?
Well, if you think about it, the emergency ones will still be scheduled first, but if you think about it, all the court appearances that we had scheduled while the courts are closed, all of those must be put back on calendar. And so they scheduled those out about 8 weeks. So we're gonna be on first, and then everything else is gonna be after that. But then you still have your priority items, the emergencies, the domestic violence. We're gonna be feeling this for the next year, year and a half, 3 years.
Are there? I assume the answer is yes. But sometimes when we have these conversations, you think of things we haven't thought of. Are there people, like for example in California, where you have to wait a minimum 6 months and a day, who were right in the middle of that process, who have now been bumped? And like they should have been legally divorced 3 weeks ago, and they're not. And is that occurring?
Yes.
Oh, God.
There's not enough. I mean, there's still a limited staff who are processing things, but they're processing the priority things first.
So auntie to auntie, this is like nothing legal, but it could mean a lot to your niece when she gets older or when you finally can connect, is that if you have the mom's phone number or you can text her and you have proof that you did reach out, you were trying to see her, maybe you send her cards and maybe you take a photo of the card and even the receipt of the date that you got it and it wasn't that you sent, just so she feels like, oh, you guys I did matter to you. It wasn't like my dad went away and no one cared about me. Just whatever you can do to show on your side for her. Not anything legal, nothing like that, but just for her that, no, I'm your auntie and I was so trying to be a part of your life and here's what I was doing. So, because that can matter a lot, to a kid or even who knows when you'll be able to see her, even if she's a teenager.
And you sound like you're doing what you're trying to do for her. So that's great advice. All right. Phone number is 888-989-9811. Back to family law questions for Lana. This one is from Neil.
Hey, Neil.
He starts by saying, I'm sure I'm not the only one with this question. I will tell you we've gotten a version of this a dozen times. Says, my attorney doesn't have a definite answer because this is such a new situation. I claim my child on odd tax years, and his mother claims in even tax years. Apparently, this is a common thing. Since I have filed my 2019 taxes already, it sounds like I will be getting the additional stimulus, the $500 check. Am I obligated to give anything to his mother? Fighting it at all would cost more than it's worth, but I would be willing to give her half. However, she also has 3 other kids with her husband, so the other part of me said she doesn't need it. So I really don't want to say anything unless she asks. Various versions of this question.
Right, and it's not settled yet. We don't know how we're going to handle that yet. There's been no directives yet. There's been lots of things kicked around as for ideas that might be a good idea. It's not settled. So if you feel that it would be the right thing to do to give half to your ex, then do so. Why does it matter? But it's not settled.
And
That's
your
attorney doesn't know.
If you're in the situation where you get the money and you don't want to give half to your ex, would you advise don't spend it because you might get ordered to give some of it later since we don't know?
You still might get ordered to give it later, so you could put it in a savings account.
Right, hold on to it. Yeah, hold on to it.
Know that you may have to give a portion to that. And we're looking, maybe it's based on your custody percentage. If you share 50-50, maybe you should give 50%. If you share 70-30, maybe you should give 30%.
I know you touched on this one earlier. Here's a different example. It says, just curious how child support will work in a situation where the non-custodial parent who pays the custodial parent child support via a court order, when the custodial parent refuses to take the child back due to COVID fear. If the non-custodial parent has the child longer than a month, can they request their child support payments stop until the custodial parent has the child back in custody? Are you following all this?
Whoa.
So wait, says, won't the parent who has the child 100% of the time need that money to support the child? Can an order be put in place if the custodial parent is not willing to work out an agreement with the non-custodial parent?
So again, there's one about filing the request for orders. If you have an order, you should follow the order, because an order for payment of money is a court order and it's enforceable. You should follow it. If you want to change it, you must file a document with the court, a request for orders to change it. So hopefully what will happen after this is that you can go ahead and temporarily change it yourself, but you have that request for order in with the court. That's that retroactive. It can be modified back. So I want people to feel comfortable to reach their own agreements right now that work for you and for your children in these emergency type situations. But it's important to have that legal document when you're going against a court order.
Given the information we have, is it a viable argument for the person who is paying the child support, who, we'll use this example, who has the kid, and the other parent, for whatever reason, won't take the kid for their version of when they're supposed to have it? Is it a viable argument for that person to say, then why am I paying you child support this month?
It's a viable argument. However, the reason you're paying it is because you're ordered to pay it. Your court order says you're going to, so you're still going to continue. If you want to temporarily stop that, you need to file that request for order with the court. Get that on file. Request for order can simply say non-payment of child support because I have the child 100% of the time due to COVID. Get that on file. And
still send the check.
You send the check until you get that on file. And then if you can reach an agreement, I'm not going to pay you during these few months because I have the child, hopefully you'll be covered because I believe you will be. But file that request for order first. Serve it on the other party. Get it in with the court service because it's notice. you need to give notice to the other party that something's going to change.
And just to talk it through, you do all that, and you can't come up to some agreement, and for 2-3 months you keep sending her child support. When everything's back up and running, you can go into family court and say, I need those 3 months back.
Exactly.
And that's a viable argument.
Exactly. Now, you may reach an agreement, though, where they say, okay, you don't have to pay me. Getting that on file kind of protects you of them saying, but it was a court order, you needed to pay me, which a lot of people do.
So, wait, did I hear that right?
Yes.
The other parent doesn't want their own kid to come to their house?
Yes. For whatever reason. Refuses to take the child back due
Wow.
to COVID fear. I mean, we don't know what that means because there's no information. Maybe the other parent lives with an elderly person whose health is
Okay.
compromised, and the kid, we don't know
That'd be helpful
if
information.
well, but this letter writer wouldn't
sounds
provide
so
that.
petty.
Well, this letter writer,
Happening a lot.
right, and this letter writer is not there to provide the good side of the other person, right?
Because the other person sounds terrible.
Exactly.
What parent?
Would refuse to bring
They would take the risk. Fine,
Right.
kid, bring COVID in. We'll have it together. I'm not going to not take my kid in.
What if you have an immune suppressed young child in your house and
Yeah.
you have a teenager who's going to visit dad, and dad has like another girlfriend and a whole nother family, and they are doing God knows what?
Yep.
You may have some legitimate reason to say, I'm not
They're just
comfortable with
leaving
this."
that out.
Exactly.
Here's a question from Heather that takes us back BC before Corona. This is the type of question you would get just on a
man.
regular basis.
Okay.
Heather,
See, I love it.
Heather says, I have been married over 20 years, and our house is not in my name, only his. Does the house still have to be split 50-50?
The equity in the house, I would assume if you purchased it together and community funds were used to purchase it, it doesn't necessarily matter whose name it's in. The equity in the home would be considered community property subject to division. So, yes.
If she played no part in the down payment, then
So the time when it was purchased is important. What date was this purchased during marriage? She doesn't say that.
Right,
If it
just that
was
they've been married for 20
yeah,
years.
just that you've been married to. When was the house purchased? Was it purchased prior to marriage? That's going to affect whether or not it's community or separate property. So it's timing of when it was purchased, and then of course source of funds. If it was purchased during marriage, but he got a big fat inheritance and just bought this house, then it's still not community property. So some important facts are missing, which is what's the date that the house was purchased, and then what were the source of funds.
And if they've been married for 20 years, if they bought it 18 years ago and they bought it together, and all the money that they showed came from, let's say, just his income because he was the working guy or whatever, and the only reason it's not in her name is that he got the loan in his name and they just never put it in her name. Now that's a different story where the answer is a hard yes.
It's a hard yes.
That in that case,
You're
it
gonna
doesn't
share.
matter her name's not on the loan.
Not at all.
That's full on community property, and he's screwed.
Yes.
All right, just like to run through all the possibilities. John L., good morning.
Good morning.
Hi.
morning.
Go ahead.
Hello.
Hi. I was wondering, my ex-husband blocked me on his cell phone, but told me I need to go through his new girlfriend.
Oh,
And we were doing that for a minute, but I said, no, I don't need to go through your girlfriend to talk to you about our kids.
Jesus.
Then we started going through my 12-year-old daughter, but I told her it was getting too much because he was being angry through my 12-year-old daughter. So then he shut her phone off. So we have no communication now.
And,
Oh, I'm sorry.
and your question is?
So is the
My question is, what do I do? I mean, how do I have contact with him? Do I unblock him or unblock his girlfriend and just go through her?
So my opinion is not necessarily legal, but it's practical. If you want to have contact with your daughter and you have the phone number of the girlfriend and that's someone you could talk to arrange that, then do it.
And
Your primary goal is to see your daughter and have communication, then do whatever avenues are available to you. Don't force someone who doesn't want to talk to you to talk to you.
moving forward, when things get normal again, does she have recourse at that point to go into family court and argue over this arrangement?
Of course, you can go into family court. You can go to family court services and see a mediator about, communication between the two of you. You can go to co-parenting classes. There's lots of things you can do to improve the communication between you and your ex for the benefit of your daughter. But practically speaking, if you have someone in that household that you can talk to and arrange for parenting time with your daughter and arrange communication, then do it.
Just bite the bullet and do it to maintain that. And it's such a reasonable approach, but in your opinion, this doesn't rise to the level of irreparable harm to the daughter because she does have a way to
She has a way.
communicate, even though it sucks.
Yes.
She does have a way, and the courts are going to go, yeah, we'll deal with this in July.
Exactly. You can still file. You'll get your hearing set out, or probably by telephone. But this is not an emergency situation. If you have a method to reach your daughter. Now, I don't like the fact that he's also blocked the daughter's phone.
Yeah.
That I don't like.
Mhm.
That gives me pause. Because he's, but basically this isn't a power control thing. You just want to see your daughter. So if that's the only, if you have a way to do that, then take advantage of it, especially right now.
Yeah, if you're not already doing this, then every day celebrate that you're not with this man anymore. And feel very sorry for the girlfriend.
There
I
you
know
go.
she's different. She'll be the one that'll change him, but she'll find out she'll be you.
Hello,
Yeah.
Chris. Good morning.
Morning.
Hi, go ahead.
Morning, Chris.
Question for you. My wife and I are married. Been married for 10 years. She has a daughter from a previous relationship. I've been in her life most of the time. My question to you is, what's going on is, if my wife was to pass away, what rights do I? Oh yeah, we also have another daughter together. But
Oh yeah.
if my wife was to pass away, what rights do I have, or what can I do to ensure that my girls stay together, or at least are in each other's life? Because our biggest fear is if she passes away, that her dad can just take her and do whatever he wants.
I'm just curious, is there a reason why the passing of your wife is imminent, or is this just like a worst case scenario?
Worst case scenario, I mean, our biggest thing is, especially with what's going on right now, is
Sure.
Everything's uncertain, and we just want to make sure that these girls grow up together.
Sure. No, I understand. I just wanted to clarify. But usually you don't ask, questions about, hey, if my wife dies, unless there's but sometimes we do because we're thinking worst case.
True. Well, I mean, my advice to you would be, one is to have an estate plan. You should have an estate plan that has guardianship, a guardianship provision.
Are you still doing estate planning?
I am.
Okay.
I'm
So I know
still doing
you worked
estate
into that area,
Yes.
so if people want to contact you for that, that's
Absolutely.
okay.
So I also do that. But having an estate plan is really important. And then, of course, your daughter, their siblings, they're going to have a bond. So in family court, there are procedures where you can request, visitation based on the bond with that child. And you as as another parental figure will also have that bond. So you can request visitation. No, I don't know anything about the biological father, his fitness, his involvement in the life. If his rights are, I'm guessing they haven't been terminated, but that's also a process. If it's an unfit parent and he may be willing to give up his parental rights, I don't know if he has any contact with the child. But those are lots of things to consider. But there's many things that you can do to maintain that bond and continue that relationship.
Man, even without COVID, this is one of those things that parents freak out about.
Yeah, well,
like if
it
one
needs to be
passes,
thought about.
like who's taken the kid, or the siblings aren't going to be able to see each other if they're different parents. Oh my God.
Right,
Yeah.
and you don't have to freak out about it. So it's just like anything. If one of us dies, there is a process for that, and it's called estate planning. You write it down. You write down your wishes and make sure they're
Yeah.
clear.
I like it when you're condescending. It's called estate planning.
Well, I know, but you know what it is? It's like
I'm not
every
being condescending to you.
No,
It's
I know-
just
I
like
know
the
you're
world.
not.
Oh, what do I do?
No, I know
there's a
you're not.
process.
Like every single person in our family and my friends, like literally when they were pregnant, they're like, okay, if the scenario is I just die, you just die, like who's taking this kid? Because even if it was one parent was still alive, they knew there was someone else in the family that didn't like that parent that might try and get involved, whatever, right? But like that was always their, I don't know, fear, but one of their things of like, oh God, I know you haven't popped out of me yet, but who's taking you?
Yeah, it is. I mean, I
Yeah.
totally understand. It's
Yeah.
it's really scary.
Here's some more emails, rad@radradio.com. This one's from Miguel.
Hey, Miguel.
So we mentioned you specialize in mediation,
Yes.
which is getting both parties not in the room now, but through video conference. What you were saying during the commercial break is actually working out amazingly well.
It's working out fabulously. I wish I'd bought stock in Zoom. I'm loving video conferencing right now.
Miguel says, answer it how you want, Lana. What does it cost to do mediation with Lana?
Well, it depends on how long it takes you. So we start off with a $5,000 retainer deposit into trust, and we work off of that. We have a series of 2-hour sessions. My hourly rate's $395. So you kind of do the math. It's up to how well we can discuss things and reach agreements.
And a lot of people don't understand the retainer system. That doesn't mean it's a minimum of $5,000.
No, gosh, no.
That's
It
like
doesn't mean
a deposit,
It's
basically.
just a deposit to get the process started.
So
and
they're
then-
incentivized. If you figure this out quicker, if you figure this in 6 hours plus your filing work or whatever, it's $1,000. Give or take. I'm doing quick math on the radio, but that can be the bill.
Sure, I have some people who do it in 1.5, 2 sessions. Now, they usually have a really good idea of how they want most of this to go, but they have a couple of issues they need help with. And then I have the people who have taken 1.5 2 years with a lot of different issues and just a lot of things to talk about. So, I mean, it's all over the board.
You ever had, I've got to believe the answer is yes. You ever had somebody go a year and a half in mediation, and then they still wind up in court?
I have not, no. If you're going to spend a year and a half in mediation, you're pretty committed to the process.
Is it still true what happens in mediation does not matter in court?
It's not admissible in court. It's a confidential process.
God.
Have you had anybody go through? I'm sorry. Go ahead.
With the exception of anything that's signed by both parties.
Mm-hmm.
Have you ever had anybody go through that much time? So it was also time and money of a year and a half, and then they stay together.
Wow.
No.
You would be a miracle worker, I think, in that case.
But I do wonder. I wish there was some kind of reporting process where they had to let me know what happens, because I wonder, did they get back together after we finished this? I really do wonder. Like, they were working so well together. I'm like, why are you getting a divorce?
Here's another BC question. This could happen anytime, before Corona or not. My 16-year-old daughter just left her mom's house permanently because she was tired of being treated disrespectfully. She has a job and straight A's, and at least, to me, her father, is an incredibly respectful young lady. If she emancipates herself, will that automatically stop the child support so then I can give it to her and put the rest in a college fund?
Nice.
Subject line on that one was, will this work?
And my reply would say, not likely.
Okay.
Not likely. She's 16. When you say moved out of her mother's house permanently, she's 16. What kind of permanent decisions is she really making? This is probably a reaction. It's likely temporary. I would not be banking on that at this time.
Come on. We had all our life figured out at 16. We knew exactly what was up.
Hello, Heather. Good morning.
Oh, hi. Good morning.
Hi, go ahead.
Heather.
Hi. Good morning. So my question is, my stepson's now 11, and when he was probably under a year old, my boyfriend that I was still with, he signed over I'm thinking it's his custodial rights to the mom. But, of course, since then, he's got his head out of his butt, and he's a great parent. So we want to know if we can reverse that.
I'd want to know more about what it was he signed. It sounds like he may have terminated his parental relationship, and if so...
Yes, that sounds correct, yes.
Yeah, so no, that would not be something you would be able to reverse.
Here's another email from Dwayne.
Hi, Dwayne.
It says, my divorce was finalized in 2011, prior to the law change in 2019, which he refers to in a moment. He says, I pay my ex $600 a month in alimony. I get to deduct the amount from my taxes, and she has to report it as income. My understanding is that for settlements made after January 1st, 2019, the payee is no longer responsible for claiming alimony as taxable income, and the payer can no longer deduct the amount. Is that true?
It is true on your federal, but not on your state, if it was in California.
My question is, if I go back to court and try to amend my alimony amount, lower it, and the amendment is dated after January 1st, 2019, will I lose the ability to deduct the amount for tax purposes?
No, as long as it maintains in your agreement, the language should stay in there. But it depends on when your agreement was reached, was it deductible on your federal or not? So in California, it remains deductible and counted as income. So I'd have to see your original settlement agreement.
Here's an interesting story. My brother and his wife are separating. They are in mediation. He left to go to Cabo for a week, came home, and she had sold all of his livestock.
Oh, wow.
What legal grounds does he have to recoup that money lost from the livestock? She had no right to sell these animals as they were with him before they were married. Okay, because reading it, I'm like, well, why is it his livestock?
Wow. Well, that's a matter of proof. You need to know what she got for it. Was it a fair market price? I don't know, but that would definitely be something to be divided in your divorce process. There can also be some sanctions in there, depending on if a petition was filed or not. You can't take that type of unilateral action after a petition is filed. Automatic temporary restraining orders go into place when a petition is filed to stop you from acting this way, taking this bad behavior. But it can be worked out in family court. Just document it, try and find out what she got for it, note what a fair market price would have been, and there might possibly be some.
But that's where it gets worked out. It's not like there's something you can't call the sheriff. There's nothing else you can do other than work it out as you finish.
People act badly in divorces.
And they're in
all the
mediation,
time,
so they should just go back to their mediator and go, "What the hell was this?"
That's a lot of
True,
work.
and that is not mediation-like behavior. So
Oh,
I'm
my
really
God.
surprised if they will
Right?
stay in mediation.
That took a lot of work on her part. What happened to just burning his clothes?
Hello there. Is that what you advise as a mediator, Lana? A burning of clothes? Oh, okay.
Do not advise that.
Hello, Ronan. Good morning.
Hi, good morning, guys.
Hello.
So my situation is, I have my ex-girlfriend, and now she got a boyfriend, and my daughter's living with a new boyfriend's house. And she told me that she wants to get the full benefit because the boyfriend is working in the military, so he wants that to give it to my daughter. And she asked me to give up my rights. So she can do that, and I don't have. And she was like telling me, is like, oh, so you don't have to pay the child support no more.
Do you want to give up your parental rights?
Nope.
Then don't do it. There's no reason why you
Yeah.
should.
This is nothing more than a business proposition she's offering him, right?
Exactly,
Hey, you don't
yeah.
want to pay child support, give up your rights. He doesn't want to give up rights, well, you keep him and keep paying child support.
Exactly.
It's that simple. Yeah. I wanted to get your thoughts on this email because it's a little long, but she wrote in and she said, I cannot wait to hear what your family law attorney has to offer about court-ordered custody agreements during the shelter-at-home order. So pause in the email. I know you touched on this earlier, and you said you're seeing guidance from most California courts in terms of enforcing orders, essentially,
Yes.
and that COVID is not a reason not to abide by court-ordered custody
It is
arrangements.
not a reason to withhold your child or deviate from your custody agreement.
So here's her story. As a constituent caseworker for an elected official in California, what does that mean?
I don't know.
Okay. Lana may be able to help me with my casework having to do with parents who don't want to follow their custody agreements during this time while sheltering at home. A case came in last week from a frantic mother wanting to know if our office could do anything about her ex-husband's insistence on picking up their 5-year-old kid for his scheduled weekend in a different county. He wanted their court-ordered custody agreement upheld even during the critical stay-at-home order issued by our governor.
As it should be.
So so far, he's the right one.
Absolutely.
Okay.
He's in the right.
She says, the letter writer says, as you can imagine, parents may not feel it's safe for their kids to go back and forth to the other parents during this critical time, not knowing the other parent's routine or if the other parent is respecting the shelter-at-home request. We've discussed this, like the concern of not putting them on a plane, okay, or taking them to church. In my constituent's case, her ex lives with his girlfriend in a different county with 3 teenagers and a brother, many of whom are still working, which means they are being exposed to the potentially deadly coronavirus. What makes this mother even more beside herself with worry is that their kid has acute asthma and a compromised immune system. If this young human is exposed to the virus, it could mean the death of a child. She tried to reason with her ex, but he threatened her that he would call the police if she didn't comply with the custody agreement. I reached out to the police department to find out what would happen if the ex showed up at the mother's door for their kid. And the officer told me that it is their job to enforce the law, which is the court order. If they were called out to the house during this dispute, they would have to hand the kid from the mother to the father, and off they'd go. So, except for the part about the kid with the having the acute asthma and compromised immune system, that sounds like what you're hearing is being suggested and enforced.
Absolutely. The court order should be followed. And there's actually, I was waiting to read this. So, a parent is not permitted to deny parenting time based upon the other parent's unwillingness to discuss the precautionary measures taken or the belief that the other parent's precautions are not sufficient. Unless they're restrained from communication and there's some domestic violence in place, parents are encouraged to communicate about their precautions. So you're encouraged to communicate about what you're doing to prevent COVID, but it's not required. And you can't deny parenting time just because I'm not sure your house is as safe as my house. That's the same thing as the other arguments being made about everything else. I'm not sure you're feeding them organic food, and I am. I mean, not to trivialize it, but
Right.
seriously.
The phrase, I think, was it immeasurable harm? Is that
Irreparable harm.
This woman you don't believe, have a legitimate case to say the compromised immune system is where the irreparable harm could be coming from.
I don't think so.
Too many
and here's
coulds.
why: because one parent is not superior at providing parenting to their child and protection to their child than the other parent. If you have a shared parenting agreement, either you have agreed previously or the court has agreed that you're both capable parents, and you don't think the father cares about whether or not the child gets COVID. Why is it only the mother that cares? And I can protect.
And there'd have to be
the other parent is gonna take precautions to protect the child.
There'd have to be some sort of whole bunch of answers of history to answer that question that would even make this legitimate. When you say, why do you think the father doesn't care about your kid getting COVID? If she can say, well, because this, and this, that's all documented, well, that's a different answer that we don't have in the email.
Well, they probably would have been in court and had different orders then if that was a risk, right?
Yeah, I mean, I'm thinking I know why they got divorced. I mean, she doesn't sound very kind toward this guy. I mean,
Hello. We have a long bad history with people named Brian, so I'm going to apologize in advance for this phone call.
Oh, okay.
Go ahead, Brian.
Brian.
Hey guys, so I need to figure out what the Brian thing is, but
Yeah, we'll let
I had
you
a question pertaining to my case. I'm in Nevada, so I lost my rights. I lost custody about 9 years ago, and we've been talking constantly about, my daughter's mother and I about, getting that back and doing it right again. I lost it because I was accused of hurting my daughter, and then when the judge saw it, he laughed and threw it out of court. Well, the judge in the different county said, we'll come back to this custody case, me not knowing that I should have filled out paperwork saying I don't want to lose my rights, figuring we would come back to this. That's how I lost my rights. Is it going to be a hard and long process to go back to this, considering I have not done anything wrong? I don't, that part was thrown out.
So it depends. I mean, are there orders in place? I mean, was there a termination of your parental rights, or do you just mean you don't have orders right now that allow you to have parenting time with your child?
No, so what they did was they gave her 100% custody. I guess I should have filled out a paper saying, no, I would like to go to court to fight this custody paperwork that she put in. But when I heard the judge say, we will come back to this, I just assumed, okay, once they figure out this bogus, child abuse charge, they'll pull me back into court, and that's when we'll discuss it. So
no, the courts never take action like that for you. They're really busy and flooded with people who are requesting that they take action. So you just need to make a request of the court that they modify your parenting plan. And it's a continual process. Parenting plans are always modifiable. So file a request for order or whatever your county uses as that moving paper and get back into court.
He's misconstruing losing custody as losing parental rights.
Right.
Which are completely different things.
Absolutely. It's never a done deal. You can go back in and request a modification and show the court, here's how it's been. It's been great. These charges were unfounded, and I would like parenting time with my daughter now.
Is he still there?
No. And we are out of
Hi,
time,
Ryan.
unfortunately.
Ryan.
Thank you so much for being here, Lana.
I'm done already? This goes by so fast.
You always give me that look, and I'm like, it was an hour and 20 minutes. But we may have to have you back as this drags on.
I'd be happy to come back in. It changes every day.
Best way for people to find you and reach you.
Look at my website, ShearerLawnMediation.com, or call me, 916-226-1305. Send me an email, Lana@ShearerLawnMediation.com.
How do you spell your last name?
Oh, Shearer.
Very good. Thanks for being here.
Thank you so much for having me.